Hello everyone, and thank you for joining us for today's Use Laboris client webinar, Coronavirus Restructuring across the APAC region following COVID-19. Today our speakers are all lawyers from the Use Laboris firms in Hong Kong, India, Japan and Australia. And to introduce myself, my name is Annie and I'm the Business Development Coordinator at Use Laboris, and I will be facilitating this session for you today. That was it from me. I will now hand over to our first speaker, Catherine Weaver from Hong Kong. So Catherine, go ahead, you are welcome to start.
Thank you, Annie. So yes, I'm Catherine Weaver from Lewis Silkin and Hong Kong, and I'm joined today by Vijay Ravi from Coach & Co. India, Nobuhito Saki from Anderson Mori and Tomatsuni, Japan, and Heidi Fairhall from Cause Chambers Westgarth, Australia. So this is a 45-minute webinar during which we intend to do three main things. Outline the situation in our respective four countries as to where we are now with COVID-19, then discuss what options are available for companies when faced with the need to reduce costs and restructure as a result of COVID-19. And then also explore what wider issues each country may be facing going forward as a result of this pandemic. And as Annie mentioned, we should have time for Q&A at the end. Now, Asia Pacific was the first region to be hit with COVID-19 due to the virus originating from China. But the region is now slowly coming out of this period and assessing the impact COVID-19 has had on the workplace, short and long term. As the jurisdiction closest to mainland China, Hong Kong was one of the first places to experience cases of COVID-19, with our first case being registered on the 23rd of January. We then had a wave of cases which were quite quickly closed down due to government and social measures. Then we had a second wave which started in late March, and that was caused mostly by Hong Kong residents returning from other countries. And this second wave lasted quite a few months. Most businesses closed their offices and enforced working from home. And then things started to return to normal. In May and June, the gyms started opening, beauty parlors, cinemas, etc. And then recently, gatherings of up to 50 people were permitted again. So it looked like everything was returning to normal. And in fact, when I put these slides together for this talk, numbers of locally transmitted cases were down to single digits. But to show how fast everything changes with this COVID-19 situation, our numbers of locally infected cases have actually increased dramatically in the last few days. Dramatic for Hong Kong, that is. So on Wednesday, we had 19 new local cases, and yesterday we had a further 16 cases. And to show how cautious Hong Kong is about this, the government has immediately implemented social distancing rules again. So restaurants are down to 8 people per table again, bars are down to 4 people per table again. And the hope that we may get foreign visitors returning to Hong Kong in late September is now quickly diminishing. And whilst this might sound a little depressing that we may have now appeared to enter our third wave, we still only have had 7 dead as a result of COVID-19, which is a relatively tiny number. And we have never had a full government enforced lockdown. When it comes to employment, almost all employees have now returned to the office, and networking events, conferences, face-to-face meetings have also begun to resume. This might all change next week though, given the recent spike in cases. The overall employment picture in Hong Kong isn't brilliant though. Hong Kong's had a bit of a tough year. We've had protests which started in March last year in relation to the proposed extradition bill, and they were continuing full throttle until COVID-19 hit us. And now we're coming through that, and we've got new protests around the national security law that has just been introduced. And this level of disruption to a city is always going to have a significant impact on the economy and workplace. Businesses are struggling, especially startups and SMEs and those in hospitality, aviation, tourism and retail. Many people have lost their jobs as a result of redundancy because of this. So to try and combat it, the Hong Kong government has introduced the anti-epidemic fund, and this aims to provide relief measures to businesses and individuals affected by the pandemic. One of these measures is the Employment Support Scheme, which gives these temporary subsidies to employers to help them retain their employees when they might otherwise have to make them redundant. But if you agree to this subsidy, you have to undertake not to make any redundancies during the subsidy period, and to spend all the wage subsidies on paying wages for your employees. Otherwise, you face penalties. So we're hoping that's going to have quite a positive impact on businesses here thinking about alternatives to redundancy. That's the situation in Hong Kong. I'm going to pass now over to Vijay, where I understand there's still quite a lot of cases in India, but you are reopening. Is that the case?
Yes, that's right, Catherine. So we, as of yesterday, the numbers are quite alarming. We are close to 800,000 affected individuals with about 21,000 fatalities. The numbers over the last month and a half have been continuously increasing, and it is definitely a cause of alarm. But despite the increasing number of cases, purely for economic reasons, and as you mentioned in the case of Hong Kong, where a lot of people have lost their jobs and SMEs and MSMEs are impacted, the government understands that we have a similar situation here. And therefore, despite the increasing numbers, the government has announced what is referred here as Unlock 2. So practically everything except a few aspects like gymnasiums or sports complexes, those kind of where you've got a more number of people coming in, except for those, commercial activities and industrial activities have been opened up. There are a few, not a few actually, a lot of containment zones that have been identified. So containment zones are areas where there are a relatively larger number of cases. So those localities or areas have been cordoned off, and people are not allowed to undertake any activities except movement for essential services. For example, if somebody has a health issue, then they're allowed to go out of their residence and visit a doctor. Other than that, in a containment zone, you are not allowed to do anything. But in every other area, commercial activities and industrial activities have started operating. However, there are a lot of challenges because, for example, public transport is still not completely operational. Metro services in most cities are not functioning. International flights are not operational. And like I said, there is very limited availability of public transport. So only individuals who have their own private transport are actually going to offices and working from office. Otherwise, practically, in almost every office, employees are working from home. And Catherine, as I mentioned when we were discussing just before we started the webinar, so I am in office today, and I am the only person in office except for a few other support staff. So I'm the only lawyer in my office. And we have a strength of about 60 lawyers in our Delhi office, and I'm the only one in office, and all my other colleagues are actually working from home. Also, educational institutions, they've had to undergo a serious change. Classes have completely moved online. So now you've got kids who wake up in the morning. Till recently, we were discouraging them from using iPads and phones and all electronic devices. And now things have taken a dramatic turn. And the first thing in the day, I hand over my laptop or my mobile phone to my daughter because she has to attend her online class. And it's tough for the teachers also because they've got to learn a lot of technology. They see a screen where you've got 30, 40, 50 students. So, everyone's learning new things. We also have night curfew. So movement of individuals is restricted from 10 p.m. in the night to 5 a.m. in the morning. Now, what that has meant is that a lot of our clients who have manufacturing setups which operate 3 shifts are facing challenges because they they are not able to operate their night shifts. However, I feel that over a period of next month or month and a half, hopefully we should be able to manage the curve. So Nobuyuta-san, I think I'll now move over to you, and we would want to know what the situation in Japan is.
Thank you, Vijay. Let me explain about the current situation of Japan. In response to an increasing number of people infected with COVID-19 late March, Japanese government declared a state of emergency on April 7th. Initially, only 7 prefectures, including Tokyo, were subject to the declaration of state of emergency. During the declaration of state of emergency, governors of each prefecture requested the people in Japan refrain from going out, recommended working from home, and shortened the restaurant business hours. Unlike other jurisdictions, these requests are not legally binding, but many people and companies follow these requests and refrain from going out at business activities. And the declaration of state of emergency was lifted on May 25th in view of the fact that the number of new infections has started to decline and has been kept below the target figures. And even after the declaration of state of emergency was lifted, prefecture governors asked people and companies in the prefecture to refrain from going out and business activities. For example, in Tokyo, even after the declaration of state of emergency ended, the governor of Tokyo asked to refrain from going out at night and from conducting business activities in certain industries until June 18th. However, as of today, all requests for self-restraint by prefecture governor have been lifted. So there is no restriction or self-restraint. And in light of this development, people have been more active in outgoings, and although not active as before the declaration of state of emergencies, and restaurants have also resumed normal operations, and people who work from home are resuming work in the office. However, as shown in this graph, the number of people infected with COVID-19 is gradually increasing as people have resumed going out. In Tokyo in particular, the number of COVID-19 infection has exceeded 100 per day since the beginning of July. And actually, yesterday, 220 new cases was reported. So there are discussion on whether to issue a declaration of state of emergency again, while the Japanese government at this moment denying that possibility. That is a situation in Japan. So Heidi, would you explain your country's situation?
Thank you, Nobuhito. So in Australia, we thought we were nearly out of the woods, touch wood, so to speak, and as at the time this slide was prepared, we had a large, well, what we felt was a large number of cases, but most of whom had recovered, and 104 deaths, which I think was much less than we were expecting at the start of the COVID-19 wave. And there's now in place in most states and territories a widespread regime of testing designed to pick up community transmission, but it's not picking up very many COVID-19 cases. But unfortunately, the big caveat to that is Victoria, which is one of our southern states, and as of 8th of July, Melbourne, the capital city, had regressed to stage 3 restrictions, which is effectively that people are required to remain at home and are only really permitted to leave their home for in narrow number of circumstances, including to work if they're unable to work from home, to attend or seek medical assistance, and to buy essential foods or access essential services. And what that has now prompted is quite an unprecedented uplift in protections across other states and territories. For example, New South Wales, which borders Victoria, has closed its border to Victoria as of the 7th of July, and that hasn't happened for 100 years. Most people know Australia is a federation of states, and generally speaking, we operate cohesively as a Commonwealth, but with the COVID-19 restrictions have now in part reverted to state-by-state based measures, and certainly with Victoria's significant uplift. I think overnight there are about 168 new cases that were detected. It's led other states to uplift their restrictions in part. So generally speaking, in New South Wales, all our borders are open, except to those in Victoria internally, that is. Internationally, though, it's a different story. We effectively close for business when it comes to travellers from other countries. Only Australian residents can return home, and when they do, they need to go into self-isolation for 14 days in a hotel. So it's a government-mandated self-isolation, a government-mandated isolation regime. And in fact, there's now state-based inquiries underway as to how Victoria's recent uptick has occurred, and there's some indication that some of those cases which led to the spread arose from hotel isolation and potentially security guards that are involved in that, and there's an inquiry underway to look into whether that contributed to the uptick in Victoria's cases. Other than that, Queensland, which is one of our northern states, has closed all its borders, and they are still closed, and they closed them quite early. But as I understand it, that's set to change today, hopefully, although that may be revisited given the events in Victoria. And in Western Australia, the borders are still closed over there. There's no indication of when they are to reopen. So we're getting a bit of a variety too in terms of the states and territories and the measures for COVID-19. But generally speaking, there's a large testing regime in place. For example, I think in New South Wales, we conducted about 19,000 tests overnight, but only 14 new cases. So it's a pretty low level incident rate at the moment in most states and territories in Australia, except for Victoria, and hopefully that will change. In Victoria, by the way, is quite unprecedented. I was mentioning to the others, we've got to the point now where we've got lockdown of some suburbs where people aren't permitted to leave their suburb, and in some cases some public housing buildings, residents are not permitted to leave the building at all and are having to be provided food, have that provided to them directly in. So let's move on to the next slide. I've mentioned our general public health directions, which are set out on the slide, but effectively a state of emergency remains, and just the end dates are going to vary from state to state. And generally speaking, in the working world, people are still generally working from home. So in New South Wales, for example, we have a public health order that requires employers to allow employees to work from home, or must work from home, except where that's not reasonably practicable. But in practice, we are seeing a slow return to the workplace, and indeed in Western Australia, I think everyone's pretty much gone back to the office. The only other thing I just wanted to mention in terms of what's happening in Australia is we had some interesting legislative developments, which I know we're going to talk about in more detail, but we had a JobKeeper scheme rolled out, which was a government support scheme which provided $1,500 a fortnight to eligible employees, and the eligibility criteria was effectively looked at the aggregate turnover of the employer. So for those who had more than, I think it was 1 billion, it needed to be a reduction in turnover by 50%, but for others it was a reduction of 30%. And once the employer engaged that exemption, that then triggered legislative changes, temporary legislative changes, which allowed increased flexibility in their ability to reduce working hours, direct annual leave, alteration of duties and location of work, which is quite significant. They're due to come to an end on the 27th of September, and there has been some discussion about whether the government's going to extend that, but really we don't know at this stage if that's likely or not. And we also saw some changes to the, we have modern awards, which are effectively industrial instrument safety net provisions, and we saw some temporary changes to those to allow for 2 weeks unpaid pandemic leave, and employees to take greater flexibility for employers to direct employees to take annual leave. Originally, those were due to come to an end on 30 June, but there's been a rash of extensions which have generally been granted. And I think that's all from me. Thanks,
Heidi. Yeah, great. So one of the sad consequences of this global pandemic, which we've all acknowledged in our opening sections, is how it's negatively impacted on businesses. There's lots of companies struggling to survive because people are just not consuming products and services in the same way as they were before. That's not to say that everyone, all the companies are struggling. Zoom being a really good example of a company that's thrived during this lockdown period. But with economies in APAC suffering, companies are inevitably having to look at how they can cut costs and survive this pandemic period. Redundancies are obviously one option, but there's other options that can be considered before that, especially as redundancies come with quite a financial burden, such as termination payments, possible litigation, and the need to then recruit and train new staff in the future. So if staff are prepared to be flexible during this tough time, then the alternatives to redundancy can actually be a better approach for employers and employees. The range of options open to companies is likely to be quite similar, I think, between our 4 jurisdictions. So I'm going to list a number of them and then invite the other speakers to add anything that's unique about your particular jurisdiction in terms of alternatives to redundancy. So in Hong Kong, clients have been considering and asking for advice on the following. Withholding remuneration, and as I note in the slide, that's mostly been considered for senior level employees, where it's been agreed with them that part or all of their salary will be withheld for a period of time until the company's finances have been improved. So it's not a salary reduction, but a withholding, and all being well, the employee should eventually receive their salary. Another option which many employers in Hong Kong have implemented is salary reductions, sometimes with corresponding hours reductions. And this is where an employee agrees either for a temporary or permanent pay cut, often in return for having to work fewer hours or days. And that's one way of instantly reducing a company's costs. But of course, you've got to get the employees' buy-in on this, and that can sometimes be challenging. That said, there have been some workforces that we've been acting for here that have really taken to working fewer hours and days and may well continue this post-COVID. A slightly softer approach is not to mess around with employees' salaries, but to reduce benefits such as bonuses and or allowances, like a cost of living allowance. These benefits and allowances are likely to be contractual terms, either expressly or through custom and practice. So if you want to change those, you also need to seek the employee's consent in Hong Kong. Next on the list is hiring freezes. That's a simple way of controlling a company's costs. And then some companies have asked employees to take unpaid leave at this time. So that could be either a sabbatical or a shorter period, just to provide some financial relief for the company. It's not possible to force an employee to do this in Hong Kong, but if employees are open-minded to this, they might think this is a better thing to do than to lose their job altogether. And also they might fancy a sabbatical. Employers have also been asking whether they can force employees to take annual leave at this time. And that's something we've been advising on quite a lot. And there's certain rules around when and how an employer can request an employee to take the statutory portion of their annual leave. But with contractual annual leave, as the amount on top of statutory, it should be possible to instruct an employee to take this as and when the employer requires. And another thought that's not on the slide is you could ask employees to change their job duties so that they're doing something more relevant and useful to the company as the company adapts and changes to this new normal. But if you're going to do anything with employees' terms and conditions, then the consent is generally required. And if you don't seek it, if you unilaterally impose any of these changes, then you could face claims for unreasonable variation of terms or constructive dismissal where the change is material. And in Hong Kong, in addition to civil sanctions, there are criminal sanctions too if you don't pay wages in full and on time. Obviously, if you've got the consent to reduce, that's fine, but if you haven't, you don't actually do it, you could be facing criminal sanctions. So they're the alternatives to redundancy in Hong Kong. Let's go then to Vijay to see what there is available in India.
Well, Catherine, India also has, or companies in India are also adopting similar modes, either one of them or a combination of some of the alternatives that you just explained. In addition to the aspects that you described, under the industrial laws in India, there is a concept of a temporary layoff. So an employer, though the provisions apply in case of factories, mines, and plantations, so an employer can actually lay off employees in case of certain situations like shortage of raw materials, lack of power, and a natural calamity like the one we are facing right now. So an employer has a right to lay off employees, uh, subject to the condition that the employees are paid 50% of their salary. Uh, the layoff can be for a period of 45 days in a calendar year. It can be extended for further periods subject to an agreement between the employer and the employees. Now, while I mentioned that this provision applies in case of factories and plantations and mines, practically what we are seeing is that companies in other sectors are also considering this option because they're able to not just ensure a reduction in cost, but they are also able to retain their talent, which is equally important. In case of factories which employ 100 or more workmen, there is a need for obtaining a prior government approval before laying off people. However, there is an exception that the prior approval is not required in a situation of a natural calamity. And COVID-19 is clearly a natural calamity. So a lot of companies have gone ahead with temporary layoffs as a measure. But otherwise, as with Hong Kong, most companies in the service sector are resorting to the alternatives that you described, Catherine. So Nobita-san, I'll now hand over the mic to you.
In Japan, let me explain about the Japan situation. In Japan, before the undertaking dismissal of redundancies, employers are required to make reasonable effort to avoid unilateral termination of employment. And the options normally considered are quite similar to those Catherine explained in relation to the Hong Kong situation. So these are the reduced non-personal related cost, access leave of absence subsidy if you can, and reduce bonuses and reduce base salaries. But the one thing which is different from the Hong Kong is about the leave of treatment of leave of absence. I understand that according to Catherine, in the case in Hong Kong, unpaid leave and forced annual leave is the option, alternative options. But in Japan, a company can order put an employees on a leave. But under the Labor Standards Act, in principle, employers are required to pay leave compensation at least 60% of employees' average wage. So unpaid leave is only allowed under the force majeure event occurred. But it is generally understood that current situation doesn't constitute force majeure event. So therefore, employers are required to pay, in principle, employers are required to pay at least 60% of their employees' average salaries. And depending on the situation, 100% salary payment is also required. And also, Catherine said that the forced annual leave is one of option, but in Japan, annual leave is considered the employee's right, and so therefore employers may not force employee to take annual leave. So forced annual leave is not option in Japan. So this is a difference from Hong Kong. That's all about Japan. So Heidi, would you explain about Australian situation?
Sure. So the one really interesting thing in Australia that the COVID-19 breakout prompted was the use of some provisions in our national employment law, which have really not been used for this purpose. And it did sort of reveal a bit of a lacuna or gap in our law in some respects. So under the Fair Work Act, which is our main national employment law, they have stand-down provisions which have generally been used for things like where there's an industrial dispute or something which is outside the employer's control, which requires work to stop, and it enables employers not to pay or to stand down employees, which effectively means that they are not paid for the period that they're stood down, similar to the concept of furlough for people who are practicing in overseas jurisdictions. But effectively, a stand down is available where in a period in which an employee cannot be usefully employed because of a stoppage of work for any reason, but the stoppage must be for a reason the employer cannot reasonably be held responsible. And so what we saw is an engagement of those provisions and a bit of a straining perhaps of the existing provisions in circumstances where COVID-19 created a dire economic situation, but there was a question mark about whether, and for a lot of employers, that necessitated a stoppage of work. Nonetheless, and regardless of whether that was accurately engaged or not, we saw widespread stand downs under these provisions in Australia, which was a really interesting use of those provisions. And for a lot of us who practice employment law, we hadn't really had much to do with those until now. As the restrictions ease, though, in terms of the government restrictions, we are seeing now employers having to look perhaps elsewhere, because it's really not possible to say now that COVID-19 is necessitating, in a lot of cases, a stoppage of work. But interestingly, the JobKeeper provisions, which I mentioned earlier, were the government's attempt to support employers in that respect, and it created its own COVID-19 JobKeeper brand of stand down, which for employers who are affected by COVID-19 had the ability to stand down employees for a period, as well as the other flexibilities I mentioned. So that's been a sort of fertile ground for employers to turn to when they're looking for alternatives to redundancy in Australia. Other than that, we do have the other access to leave style leave burn. And the interesting feature of the stand down, and we saw a case go up to one of our higher levels of courts, which is Qantas, which is our national airline, stood down, I think it's nearly 95% of its staff, and would not allow them to take sick leave while they were stood down. And that was a bit of a test of our legislation. And ultimately the court ruled that employees were not entitled to access sick leave while they were stood down because they were not at work. And that was one of the requirements to be able to access sick leave, which makes some sense and logical sense, but not necessarily on some people's reading of the legislation. And otherwise, employers in Australia are using widespread renegotiation by agreement of salaries and working hours, but the JobKeeper changes, so the temporary changes to our national law, did enable some employers to basically, subject to a period of consultation, unilaterally direct employees to alter their duties or their hours of work while they were receiving the JobKeeper subsidy, which, as I mentioned, is an amount of money that's paid to employees per fortnight by the government. I think, do we have another slide? Yes, so other than that, leave without pay, the other element we saw is we have a lot of enterprise agreements, which is another layer of industrial instrument that's available in Australia, which are essentially industrial instruments that are negotiated at enterprise level, as the name suggests. And the government during the COVID-19 crisis introduced provisions to allow those to be amended with very short notice. Really, employers only needed to give employees 1 day before they could put it to the vote. I think the government expected a lot more employers to avail themselves of that, to make amendments to their industrial instruments to help them through the COVID-19 crisis. But as it panned out, very few employers used that reduced time frame, and as a result, the regulation has ultimately been withdrawn, which leaves employers in a space where they can still change their enterprise agreements. They have to put them to an employee vote, and then that needs to be approved by our National Industrial Tribunal, the Fair Work Commission. I think it's fair to say some employers certainly have followed that route, but it's not been as widespread as perhaps some expected.
Thanks, Heidi. For the next part, we're going to talk about redundancies and how to implement those in our various jurisdictions. And I'm going to ask each speaker to only speak for 2 minutes. So please try and keep to time so we can at least touch on the last part of this webinar and a bit of Q&A. When it comes to redundancies in Hong Kong, it's pretty simple to administer. There's no statutory redundancy process to follow, no compulsory consultation, no obligation to seek suitable alternative employment, no redundancy reporting obligations. In fact, the only thing the Hong Kong Employment Ordinance really focuses on is the severance payment to be paid out on redundancy. And it's actually in that section of the Employment Ordinance under severance payment that you find the definition of redundancy there. And it will be a similar definition to the other jurisdictions, I think, so I won't go into what it is. I set out on the slide also what the common law definition is. So while there's no statutory process, there's still a number of potential pitfalls that employers can face when they're implementing redundancies in Hong Kong. I'll quickly list 3 of them. The first is in relation to selection criteria. So if that's used to select employees for redundancy and it hasn't been objective, it's quite subjective criteria, then employers can face potential discrimination claims. The second one is there's certain employees in Hong Kong that you cannot dismiss, other than if they do something worthy of summary dismissal or during their probation period. And these protected employees, there's quite a few of them, but the key ones are those receiving statutory sick pay, so those on sick leave, those who are pregnant or on maternity leave. There's a few other categories, but they're kind of the key ones that come up quite often in the advice that we give. You can't make these people redundant. It's a criminal offence to do so. So important point to note. And thirdly and finally, an employer must ensure they pay out the employee's termination payments correctly and within 7 days of the termination date, because if you don't do that, that's also a criminal offence. When it comes to the severance payment, it's actually got slightly different timing. And I'll touch on that in a second. An employee's termination payments include all the usual things: final salary, accrued but untaken holiday, payment in lieu of notice, etc. But touching on the statutory severance payment, how that works is you are entitled to it if you have 2 years or more service with your employer. And it's a statutory formula. So it's calculated by taking 2/3 of an employee's last month's wages, capped though at 15,000 Hong Kong dollars, and then multiplied by years of reputable service. And you also have to prorate for any part of a year worked when you're calculating it. And in terms of when that has to be paid out, it's as soon as reasonably practicable, or at least within 2 months of an employee making a request for the severance payment. So in reality, it's often paid out at the same time as the other termination payments, so within 7 days of the termination date. And I'll just reiterate here that what I said before about the employment support scheme coming in. 75% of employers in Hong Kong have actually applied for the first tranche of that support scheme, that subsidy support scheme. So we are thinking that this will have an impact on redundancies going forward. I think I stuck to my 2 minutes, so I'll hand it over now to Vijay.
That was well done, Catherine. Yeah, I'll try to keep to the 2 minutes myself. Now, when it comes to redundancies in India, I think the first step is to determine the category in which the affected employee falls. So under Indian laws, we have 2 categories of employees. One is referred to as workmen, which is typically blue-collar employees, not necessarily factory employees, but these are individuals who, as part of their normal duties, do not exercise any managerial or supervisory authority. So they're typically at the lower rungs of the organizational hierarchy. And the rest who exercise managerial or supervisory authorities are referred to as non-workmen. Now, when it comes to redundancies for non-workmen or white-collar employees, it's based on the terms of their employment contract. They are not entitled to any statutory severance payment. If it's contractually agreed, then they have a right to receive statutory severance. Otherwise, the terminations are purely based on the employment contracts. When it comes to workmen, they have certain statutory rights. And as Catherine mentioned, in case of Hong Kong, the right to receive severance payment is for employees who've completed 2 years of service. In India, the timeline is 1 year of service. So any individual, any workman who's completed 1 year of service with an employer is entitled to statutory severance. You are required to follow certain conditions when it comes to terminating the services of workman category employees, there is a minimum of a 1-month notice. If you've got 100 or more workmen, then the notice period increases to 3 months. That's a mandatory requirement. In case the employment contract has a higher notice period, then that applies. When it comes to the severance payment, it's calculated at 15 days of salary for every completed year of service, or a period in excess of 6 months. So it's rounded off to the next 1 year. And there is no cap on the amount of retrenchment compensation. Following the termination, you are required to intimate the jurisdictional labor authorities about the termination. In certain cases, especially where you have 100 or more workmen, prior to redundancy, you are required to take the approval of the government. There are no consultation requirements statutorily. However, if there is a trade union recognized, then usually there is a process of consultation that is employed. Ordinarily, you are required to follow the last in, first out principle for selecting workmen who would be made redundant, unless you have a reasonable justification for deviating from that principle. So I guess, Catherine, I've also managed to stick to my timeline. I'll now hand over to Nobuhito.
Thank you, Vijay. I would like to explain about the Japan situation. In Japan, there is a concept of the dismiss for redundancies. But according to the established court precedent, it is quite difficult to undertake a dismiss for redundancy because there are 4 requirements which must be met. And then in practice, it is quite difficult to satisfy all of those 4 requirements. And requirements are, as explained in this slide. The first one is there is high and reasonable necessity to reduce the workforce. And second one is the company has made every effort. So it is, this slide is a bit misleading, but every effort to keep employment. And one of such measure is cost cut. But so please change this. And third one is criteria for selecting the employees to be reduced fair and reasonable. And the last one is the company has explained and discussed in good faith with the relevant employees or the relevant labor unions. And one of the most frequently asked questions from the foreign company, especially a UK or American company, is because we eliminate this job function, so it is okay to dismiss that person based on that reason? And the answer is normally no, because as a second factor, we need to make every effort to employment. So which means that the company, as client, must offer another job to the targeted employee. So that just job elimination is not enough. And in addition to notice period, at least 30 days prior notice is required. And in addition to the statutory severance payment, unlike other jurisdictions, there is no statutory severance payment is required. And the filing is required in addition to limited circumstances. If 30 or more employees are expected to leave the company, a filing to Hello Work is required. But this filing is required in addition to the subsidy. So even if filing or approval are not granted, that would not affect the effect of the termination for redundancies. Would you move on would you move on the next slide? Because the redundancy dismissal for redundancy is quite difficult. In practice, it is quite common to offer a separation package and terminate the contract of employment based on a mutual agreement with the targeted employees. And there's no statutory requirement for severance packages, so in practice, it is common to follow the internal precedent, if any, or discuss the amount of severance package with the targeted employee. And you also need to take care about the order of workforce reduction, because in Japan, the regular employees' employment is quite heavily protected. So before undertaking the termination of regular employees, you need to suspension of new hiring or cancellation of offerable employment or termination of non-regular employees. Those are what I would like to explain about Japan. Heidi, would you explain about your country's regulation?
Sure. Look, I'm conscious we're short on time, so I just wanted to hit a few key points in relation to Australia. Redundancy is a statutory recognised concept in Australia under our Fair Work Act. So we have minimum employment standards in our legislation, and severance payment, redundancy payment is one, and it's up to 16 weeks depending on years of service. It sort of caps out at about, I think, 10 years. If you've worked for at least 10 years for the same employer. Generally speaking, it's available to employers to make employees redundant, but if employees are covered by a modern award or an enterprise agreement, they have an obligation to consult with employees when they've made a decision about a major change, and redundancy usually falls in that category. So if they're going to make a major change to their operation, organisation, programs, etc. So widespread structural change would definitely tick that box. If it's going to have a significant effect on employees, such as result in their job being removed, then they need to consult with employees and their legal union representatives if they have one. Now that's an obligation to consult about the decision that has already been made, but prior to implementing the decision. So what you'll see with redundancy is employers will make a decision to make structural change, including redundancies, and they will need to consult with employees about how they're proposing to do it before they finalise their implementation plan. And then after the consultation, which doesn't equate to agreement, but just a listening and actively taking into account what employees have to say, then they can implement the redundancies. Another feature of our legislation is that if you're making more than 15 employees redundant, in an organisation, you have to notify Centrelink, effectively our government job agency, and you also need to, there's also an obligation in legislation to consult with the union if there's more than 15 people being made redundant in one organisation. Those are sort of, I think, features of our legislation, and generally speaking, employers can apply to our industrial tribunal to have redundancy payments reduced potentially to zero if, for example, they find alternative employment for the employees. Do we have another slide? Effectively, that's what I really wanted to impart in relation to Australia for redundancy.
Great, thank you, Heidi. Thanks everybody. We've now covered the main topic, which was redundancies, restructuring. We have got some more to talk about in terms of key issues that are related to COVID and some longer term impacts on the workplace. So please do stay around if you can for another 10 minutes for this part of the session, and also Q&A. If you have to drop off though, then we entirely understand. I'm going to hand over to Vijay. I think we're all going to come off mute now, so we can just freely talk about these interesting kind of subtopics related to COVID-19.
Yeah, thanks, Catherine. So I think one of the aspects that clearly COVID-19 has brought about is the flexibility in the workplace. We never visualized a scenario where practically the entire world would be working from home, and work from home seems to be the new normal. And the way we look at it, I think it's going to be a situation for the foreseeable future. In fact, the largest Indian IT company, Tata Consultancy Services, which employs almost 450,000 employees, has actually announced that they plan to have 75% of their staff working from home by the year 2025. Now, that's significant because we see a lot of other Indian companies planning on similar lines to have a permanent work from home model. Now, India presently does not have a legal framework for managing a work from home scenario. I believe that we will have some legislative framework going forward, because increasingly there are going to be issues that arise as a result of employees working from home on a permanent basis. There may also be a need for companies to look at their HR policies to address issues that may arise as a result of employees working from home. The others, I'm not sure if there is anything that's specific to your jurisdiction or something interesting that you may want to talk about.
BJ, I was going to say, and maybe India's not dissimilar, one challenge that the flexibility in the workplace has brought in for a lot of employers in Australia is for those employees who are covered by an industrial instrument, the ability to work any hour, whatever hour, so long as they get their job done, has potentially raised some problems for employers, because a lot of modern awards have a span of ordinary hours, which then if employees work outside those hours, that engages the requirement to pay overtime or shift penalties, etc. And so where employees are not working in a structured sort of office-based environment, employers aren't always having visibility or control, and may not necessarily want control over it, but it's causing some issues for some employers in relation to unanticipated potential claims for overtime, and it's exacerbating what is generally an emerging issue, I think, in Australia, which is the payment of annualised salaries, which cover all of the award entitlements. But it's something that flexibility has brought to the fore in Australia.
Well, in fact, I'm sorry, Catherine. In fact, Heidi, I actually understand completely what you're saying. Just a couple of weeks back, I was speaking with a neighbor of mine who works with a FMCG company, and he said that since the time I've started working from home, it seems like work never ends. And I think it's the same for a lot of us, because we're practically working 12 to 14 hours, if not more. Sorry, Catherine, please go ahead.
No, that's fine. Actually, that's an interesting point you raised, because I think it's going to come on to a topic we're going to go on to around health and safety and mental health. But just putting that to one side, in relation to Hong Kong, I mean, the culture here really isn't one of home working. There's certainly no legislation around it. And if you'd told Hong Kong that in 2020 that everybody would be working from home, I think there would have been a large chuckle. Just not really culturally, socially what people do here. But we've proven that we have done it. I think HSBC was working from home for about 6 months. And so it'd be interesting to see whether there'll be now a shift towards more acceptance of home working. I expect it probably won't be fully embraced just because of the living situation here. People live in very small apartments. They often live with other people, family members, they're fighting for space, and you work quite close to where you live. So it's pretty easy to get in. There's no commuting issue. So I think we will see some changes, but I don't think, unlike other places, we'll be embracing it entirely, and everybody will be leaving their office and working from WeWork or from home permanently. Anything from Japan on this one?
Yeah, in Japan, the situation is similar. Before the COVID-19, working from home was not so common in Japan, but during the state of emergency, lots of companies in Japan introduced working from home. And after it was lifted, many companies have maintained working from home as an official system. Actually, today I connected during this conference from my home, and before COVID-19, I couldn't imagine that situation happened. So that way of working with Japanese people in Japan will be gradually changing.
That's true, Nobuhito. And I think another aspect that would be relevant when it comes to working from home, which Catherine also briefly mentioned, is the health and safety aspect. And things will definitely change as we move along. Now, in India, we've already seen a start of discussion around possible mental health issues as a result of employees permanently working from home. So there's already a discussion around that subject and how to address any possible as a result of mental health issues. There are also issues related to physical health, because not every household has ergonomic furniture available. So a lot of companies have actually started giving out allowances to employees, so that they can purchase office equipment which is comfortable, to make sure that employees' physical health is taken care of. Now, once there's also another point which I wanted to mention. Following the opening of the industrial establishments and commercial establishments, the government has made it mandatory for employers to have insurance for employees, which was not the case previously. Now, I would definitely want to hear if in other jurisdictions there are health and safety issues that we may have to look at.
We might need to move on to Q&A, Catherine.
Yeah, I've just seen there's 3 questions for me. I think 2 are similar though, and they're kind of related to this point. So let's address those. There's questions around working from home. If we do have working from home, is there anything we need to be aware of? Are there any laws and regulations on working from home in Hong Kong? And that's a similar question. So there's no law specifically on working from home in Hong Kong. What you do need to bear in mind though is what we're talking about is health and safety, and ensuring that the workplace for the home worker is a safe place, because your obligations do stretch anywhere considered to be the workplace. It brings up an interesting issue around employee compensation insurance, which should cover the workplace too. And I know that there's clients of ours who had problems trying to get insurers to cover the home under employee compensation insurance. So it's something to bear in mind, but it's your usual obligations of ensuring that you are taking reasonable steps to provide a safe place of work for all employees. So that's what you need to bear in mind when people are working from home. There's other less legal points around supervision and other things to be thinking about in that regard. Shall I address the other question, Heidi, that's been put in the Q&A?
Sure.
Okay. And the other question for Hong Kong was in relation to part-time workers, and not knowing necessarily how many hours these people are working. So it's negotiated between the supervisor and the job holder. Will these people be entitled to statutory severance? That's a good question. So those that are entitled to statutory severance have to be what's called continuous employees, and they have to work for 18 hours or more a week for 4 weeks continuously. So if there are part-time employees and they're working for less than 18 hours a week, they wouldn't fall under the protection of the employment ordinance and therefore would not be entitled to statutory severance on termination. The difficulty, I think, in the scenario that has been put forward by the person with the question is, if you don't know what's being negotiated with the supervisor and job holder, then there may be circumstances where for a week they do go into the 18 hours plus, or for several weeks, and suddenly you find yourself, without even knowing, being subject to the employment ordinance. So it's something really to watch out for and to keep proper records of, because as soon as the employment ordinance kicks in, there's a whole raft of rights that employees then have. I see there's a question for Japan. Sorry.
There was one question. I think, though, I'm getting an indication that we need to wrap up.
Yeah, that's from me. We're very conscious of time, so I'll just need to wrap up. And so unfortunately, we won't have the time to take any more questions, but I will hand over all the questions that came to the speakers so that they can get back to the attendees by email. I think that's the best solution here. And it's nice that we're getting questions, though.
Sorry, I noticed that just one question to Japan, and the answer is quite simple. So
yeah, go ahead. Yeah.
The question is, Japan is well known for being a difficult place to terminate employees. However, during this time of COVID-19, has the government put any provisions in place to help employers or make this process more flexible? And the answer is no, there is no special treatment. Rather, the government is requesting employers to keep employment and not undertake dismissal. So therefore, unfortunately, there is no special treatment to ease the dismissal process more flexible.
Thank you, Nobuhito. That's true. That was very, very quick. So just for me, I'd like to say that if your query somehow is related to another jurisdiction, you can go to our website to find the right contact. We have the people page. From there, you can find a right lawyer contact for you for any other query you might have. For any other information and further updates you would like to have on the coronavirus, we also have a coronavirus page on our website with many resources. For example, this coronavirus guide that we have for international employers, which contains information from more than 50 countries. It's 58 now, to be exact. So with that, this webinar will now be ending. Thank you all.